Let's return now to the Solicitor-General advice on Scott Morrison. Bring in Professor George Williams. George, thanks for your time. First of all, unusual, Professor Williams, isn't it, that this legal advice has been released in the first place?
It is. Governments normally keep advice from the Solicitor-General very close to their chest. It's very hard, in fact, to get them to reveal it. So it shows here two things. Firstly, that this is a matter of such public interest, and the Solicitor-General is the right person to inform the public about what happened and what was right and wrong. And also, of course, the government sees political advantage in releasing the advice. So that's the reason, I think, on both counts for the exception here.
And let's get your assessment then of the advice. I think it is pretty much in line with what you told me last week, that maybe to the letter of the law, it's valid, the appointments, but when it comes to the Constitution, it undermines the spirit of the Constitution. And in the words of the Solicitor-General's advice, he says, the principles of responsible government are fundamentally undermined.
That's right, and the advice is unsurprising except in just how forceful it is. It's unsurprising because there are so few rules in this area. You can't break the law if there isn't a law to say that you need to be transparent and you need to do something as obvious as tell people you've been appointed as a minister. So in the absence of law, it is lawful, but that doesn't make it right. And that's where the Solicitor-General's advice is very strong. Yes, says it fundamentally undermines our system of responsible government. And in other respects, also it's scathing in saying that this goes to the heart of our system of government and that the whole system of accountability breaks down. How can you even have something as simple as question time if you don't actually know which ministers have been appointed to administer a department?
And when it comes to plugging that gap, so to speak, to make it explicit, does that require legislation now?
Well, there's a couple of options. There is the possibility that the government might just change the practice. It might adopt a practice of making sure every time something like this happens, it goes in the Gazette or another public document. But the problem is that could be changed in the future. And in fact, a future government could secretly change the rule. And again, we could end up in this situation. So personally, I think that the only reasonable answer is Parliament does need to legislate. The rule's been shown that it's not enforceable, it hasn't been honoured, and this does go to the heart of Parliament's role in our system of government, and Parliament should make it clear that it expects every time to know when someone has been appointed as a minister, and legislating for that basic standard of transparency is, I think, a sensible next step.
Yeah, because some of those practices even then can be amended. It's paragraph 42 of this advice that says that the lists that were put to Parliament had a caveat included on them from at least 25 January 2019. That was an interesting thing to pick up on reading that advice, which suggests that the list may be not full in terms of its explanations of ministerial responsibilities.
Yeah, and there's quite a sting in that paragraph because it's suggesting that this was done with full knowledge that this would not be acceptable and that Parliament would be up in arms if people knew, and that it would actually be misleading Parliament. So those words were put in to say that you can't rely upon this list. People may have been appointed to other portfolios, but at the time nobody made anything of that because they thought that surely no one would do what the Prime Minister did. At best, it might be an extra portfolio here or there, but of course something quite different happened, and we've ended up in a situation that could lead us down a very dark path if we don't actually make sure we fix this now.
The Prime Minister said that there will be a further inquiry to be conducted by someone with a legal background, an eminent person to undertake that. Can you see why he's chosen to look further into this matter?
I can, because the Solicitor-General's advice says it was lawful but wrong that it occurred. He looks a little at the end about solutions around legislation, but not in any great depth. And also what it shows is that even though we've really focused on the appointments of Scott Morrison, in fact, there are larger issues involved as well. Both this government and prior governments have not been as transparent as they should be in just making it clear which ministers are exercising which portfolios, who has the powers at their disposal. And so we need a broader fix to make it crystal clear at any particular moment who is exercising these powers, particularly during something like a pandemic when the powers are so extraordinary. An inquiry will both get to the bottom of the implications of the Solicitor-General's advice and, I think, settle on a solution. I'd also say, though, that it's not all we need here. We still need that Royal Commission into the pandemic. This has come to light quite fortuitously. What else is it we don't know about what governments have done in this area? And more broadly, we need to make sure that we get to the bottom of how governments have responded to rebuild some community trust. Because unfortunately, this episode really plays into fears and conspiracies around government secrecy and secret powers that we need, I think, now to add some more sunlight.
Indeed. In this context, though, with this inquiry specific to the matters around the secret portfolios, the Prime Minister said there would be a forthcoming Royal Commission or inquiry of some sort once we're through the pandemic. But on the Morrison matter, do you think that it's almost a blessing in disguise, Professor Williams, that this has emerged so that the vulnerability there can be shored up, so to speak?
I definitely think so. It is to our fortune we discovered this at a time when, apart from one decision, the other powers weren't exercised. And it's fortunate because it created a precedent. Future governments may well have decided to follow the same path, in secret, to confer powers not just on the Prime Minister but other ministers as well, in ways that really do fundamentally erode our system of responsible government. Our system depends upon these conventions being obeyed. And we need now to take a stand. It's a major wake-up call for the system, and to insert requirements, lawful requirements for transparency that we've assumed to this point. But the evidence sadly shows that that assumption was flawed, and we now need to set down rules that are enforceable.
Yeah, they absolutely were assumed going into Parliament, and when you hear the ministerial changes announced, I certainly had assumed that that was always done when there were changes made. Obviously not that. That's not the case. But when we do get to that Royal Commission stage, as you've reiterated your support for, what are the legal and constitutional issues that you want to see covered in terms of the way that's dealt with? Obviously, you've said you want it to help rebuild trust in government with the Australian people. But what about the way federal and state governments interact, for example?
Yeah, we need it to be very broad-ranging. And you look to the United Kingdom, for example, which is embarking on a similar process. And if a nation has faced the largest public health emergency in many, many decades, perhaps a century, if a nation has spent billions and billions of dollars in remedying that, and people have been locked in their homes and their most basic liberties removed, it's right after the event to ask questions. Did our governments get it right? So that's the economic, the political, the health, and the individual liberty dimension. And we need to do that because we need to assure ourselves that governments have acted always in our best interests. And we need to learn the lessons. Were the lockdowns always needed? Was Western Australia right with how long it closed its border for? Did we actually have the right mechanisms in place between federal and state governments? Was National Cabinet a good idea? And were these truly extraordinary powers conferred upon ministers, which, after all, led Scott Morrison down this path in the first place, given the powers in the Biosecurity Act? Are they in the right form, or is it actually right to revisit these godlike powers and to rein them in a bit? Because, frankly, they weren't needed in that form to deal even with this emergency.
Indeed. And just finally, before you go, I've got to ask you about the secret portfolios drama. Is the Governor-General vindicated by the advice as released today?
Well, he's certainly in a sense that he did his job. When it comes to the formal aspects of conferring these ministries. The advice is definitive and not surprising that the Governor-General must follow the advice of the Prime Minister. And in fact, if the Governor-General had not done so, that would have been a genuine constitutional crisis, getting us back to 1975 territory if he'd gone outside the guardrails. Questions will still be asked about whether the Governor-General could have advised or warned, asked more questions perhaps. But the bottom line is he did what he's told, and he had to do what he's told. And it's good that his office wants to collaborate, participate in this inquiry, because clearly they also recognise these processes can be improved. And I think that's the right response. And in the end, we've got to recognise the Queen's representative, bound to follow the PM's advice, was always very limited in what they could have done.
Expert in constitutional law at the University of New South Wales, Professor George Williams, thanks for your insights as always.
Thank you.